on lines 491, it picks up the revisions to the code section that we've already been through. And then section 6, the change is on line 614 through 621, and it requires the Secretary of State to provide a form for the registration of the lobbyist and disclosure of the financial interest. It's a brief explanation of the bill. I'm happy to entertain any questions.
So, Senator Thompson, as I understand the bill, the situation would be that a lobbyist can lobby for any issue that they want to, just, like we have now. But if that lobbyist had an ownership in a company, say, that they were lobbying for, and as a result of that lobbying, they would potentially gain some advantage or some interest at doing that, that disclosure would have to be made. Is that a pretty accurate description of the bill?
Yes, Mr. Chairman, I would analogize it to when an attorney is representing a client, he's wearing a hat as an advocate for that client. And the tribunal or the other attorneys that he or she is practicing in front of recognizes that. But when an attorney has a ownership interest in a business transaction with a client, that's different. You're no longer an advocate. Now you're contracting with your client. You have a business interest with your client. That has to be disclosed. The client has to consent to it, and you can no longer advocate for your client. For that client, you now have to get another attorney. This is for those situations where a lobbyist has an ownership interest in a business that stands to benefit from legislative action, separate from, say, whatever their fee agreement is with their client when they're advocating for their client in the legislature. This is if a lobbyist has an ownership interest in a business, that it must be disclosed.
And as I read it, it applies to a lobbyist. It doesn't generally apply to the entire firm. So if you had, for example, a firm of lobbyists that had, multiple members, I just want to be sure we're understanding what we're talking about here. If there are multiple members of the firm, and there's only one who would have a material benefit, from the passage of said law because of a corporate ownership of something, that lobbyist then would have the duty to disclose. But the other ones within the firm who would not materially be benefiting would not have that duty. Is that the way the bill is drafted?
That is the way the bill is drafted. And I think I would go back to the definition of lobbyist on line 173. And that definition describes it as an individual, not as a firm.
Okay, you've heard a discussion of the bill and you've heard some questions. I'll yield for Chairman Thompson to receive questions. Senator Turner Ford, questions for Senator Thompson.
Thank you, Mr. Chairman. Looking at line 331, and it appears the lobbyist is required to provide a list of specific bills or regulations for which the lobbyist was employed. And that's another code section, which is 5-8-9. So would the lobbyist be required to do that regardless of if they have a pecuniary or financial interest in a business?
Yes, that's an additional reporting requirement to that list that's underneath subpart 3, A, B, C, D, and E. Those A through D are the current reporting requirements. E would add that the issues, and the thought process there is it would tie back to that disclosure of the proprietary interest. So if you have a business that, separate and apart from your lobbying business that does not have any issues being lobbied for, this would help make that distinction. You're lobbying for issue A and your business is in a totally different sector.
That particular language would be that's a general reporting requirement, right? It really doesn't have anything to do with pecuniary or financial interest. This is the report that the lobbyist must file, and as a part of that report, they have to disclose every bill they've worked on.
This would be the. Yes, I guess that's the way it's set up right now.
And so, my question: what is the purpose of requiring that element of the report?
put the procedure in motion with the prohibition against, not prohibition, the requirement that you have to file your interest with the legislative leadership. This is what would trigger that. You have to list the bills that you're interested in. It's just part of the procedure.
So I think
So
to
the-
Turner Ford's question, I think your question is, because as I understand it, is the list inclusive of every bill they lobbied for? Or is it just limited to the ones that they would have some, corporate connection to? And I would certainly, in my understanding of the bill, consider it a friendly amendment, as I understand the text of the bill, to make that clear, because I have no desire to make every lobbyist disclose every single bill and interest that they have during the session. It's only for this particular situation. Is
And-
that okay with you, Senator Thompson? Is that your understanding?
That's the intent of the bill, yes.
Yes.
But I think it's intended to be all inclusive because the person making the reporting, you're putting him or her in the position of making a determination if there's a financial interest. So if you're required to list everything, then the Secretary of State is regulating this whole thing. That's the purpose of it.
So the first code section of the bill is 5-8-3. And that's where the definitions, I guess, for the material financial interest and pecuniary benefit are listed. But then another code section under section 2 requires, would be a separate statute, will require all of these reports, all of the bills be specified and listed in a report. And so I would like to be recognized to make an amendment when appropriate.
So I will, let's see if there's some more questions or maybe some other discussion and maybe amendments as we go through this here. So does anyone else have any questions before I recognize Senator Turner Ford for an amendment? Senator Williams?
Maybe just a point of clarity, if I may not be understanding. The intent is for the lobbyist to report to ethics as we do. If we have an ownership in all businesses, like I've got to do that report every year. And if I've got an ownership and interest in any businesses, I report that, not the specific bills that I may or may not be working on, but it's just those businesses. So if lobbyist A has ownerships in 4 businesses, they're going to report those 4 businesses. Is that the intent here? And we just, the words are kind of encompassing what they're lobbying for?
If I may respond, I understand what you're saying is the perceived intent, but the text of the bill requires that they report every bill that they work on. And I don't know exactly what the intent is, but this is what the bill does.
I agree. I think that we can probably pick up that additional reporting requirement that starts, I guess the first one's on 256, and clarify what I believe your proposed amendment's going to be.
State my proposed amendment
That
when recognized.
only for the bills that could or involve that pecuniary interest.
So Senator Turner Ford, I think as I read, kind of the biggest portions of it is that the reporting, instead of it just being, Senator Williams' point about to ethics or whatever our normal filings are, is to make it specifically apparent to the Lieutenant Governor, Speaker of the House, and the chairman of the committees to which the legislation is assigned prior to floor action of the full Senate or House is a different situation than what you're describing, and so I don't know yet what your amendment might be, Senator Turner Ford, but I think it might be appropriate, and I'm going to let you offer whatever amendments you have, but it might be appropriate to strike that line that 331 through 333. And that might
333 to 336.
I think may I state my amendment?
Sure. I think we're working towards the same goal. And so I'm trying to find something that might achieve that.
So I would move that language be stricken. I see no problem with a lobbyist having to self-report the bills or businesses that they have an interest, but I disagree with them having to specify any and every bill that they work on just on an annual basis, regardless if they have an interest or not.
Just to be clear, Senator Turner Ford, lines 256 to 258, and then it's repeated again at 333 to 335. So the amendment would be to delete those two.
Yes. 254. It also appears at 331.
Council, do you see any other location where we may have the same language beyond what we're finding there? So again, this is additional education and thought. Also called mics don't work in here. I guess, Senator Blunt, unless you have a question on Senator Turner Ford's amendment first, the question recurs on the adoption of her amendment to remove those sections. So all in favor of removing the sections per Senator Turner Ford's amendment, say aye.
Aye.
Any opposed? Yeah, that amendment will be adopted. Senator Blunt.
Thank you, Mr. Chairman. This is a committee process at work. I think what we're left with is the report that's made to the Lieutenant Governor and the Speaker of the House and the Chairman of the committees. But what we don't have now is, it seems to me that information should be included in the filing with the Secretary of State, which is available on the website. And we don't have that. So, I mean, that should be, to me, that should be part of the registration that a lobbyist files. So in addition to the disclosure to the Lieutenant Governor, Speaker, and Committee Chairman, I think we need to put it back in the information that goes into a lobbyist registration, because I know that's when I'm looking for information on lobbyists, that's where I go. And so otherwise, the letter to the Speaker and Lieutenant Governor is not going to be on the internet. It's going to be a letter that goes to his office. It's going to be there.
Senator Thompson, if you would
Unless
reply
I'm missing
first.
something.
No, it's in section 3 of the bill. That's code section 5-8-9. And from my read of that is the lobbyist report to the Secretary of State. And if you turn to line, that starts on line 282. And if you turn to line, I got an old version of the bill. What do you show me? Well, it's at line 368. It's at the very end of section 3. That's the report. That's the information that would be reported to the Lieutenant Governor and the Speaker. And then that is in that section of what goes to the Secretary of State.
What I'm trying to achieve is any disclosure of financial interest is filed with the Secretary of State as well as the Lieutenant Governor, Speaker of the House. That's what I'm trying to achieve. And I don't know if we're there or not, but if we're not, I want to make sure we are.
Guess, in interest of time, and because I haven't had discussions yet with Secretary of State about this bill yet, although I've had discussions with him about every other bill, it seems like, but it might be appropriate to let's you and I work together on a potential amendment, maybe for the floor, instead of putting a reverse repealer in it and, and kind of slowing it down. I'll work with you on that and Secretary of State, see if we can find a solution if we're able to advance this out of committee. Additional questions from the committee? Seeing none for motion, Senator Thompson.
How sufficient do pass committee sub as amended? No.
Just committee sub.
Committee sub.
So you hear the motion, all in favor say aye.
Aye.
Any opposed? Okay, that bill will be reported. The next bill we have joining us, Senator Boyd. She explained this bill really well in public health. It's a fairly long bill, but it's got more of the meat kind of at the beginning of the bill. So recognize her to explain her bill.
Thank you, Chairman Parker. What you have before you is an act that would establish a community health worker certification program in the State Department of Health. This bill was brought to us by the State Department of Health and Dr. Edney particularly. Last year, when I started working on the women and children's issues, we went to a lot of national conferences, and a key component in whether you were looking at maternal health, early intervention, or looking at mental health was something that we don't have really that many of in the state of Mississippi. And that could be paid for by Medicaid too, is our community health worker program. And if you're not familiar with what that program is, it's part of a broader field of public health, focusing on health, well-being, really at the community level. It usually is a trusted member of the community that often is from the same community. They share similar backgrounds, languages, they build trust among those community members, but they help people bridge the health system. They connect people with health services, social resources, and they help people navigate a challenging health system, which can be complex and challenging given the educational levels that we have in large parts of the state. They become a health advocate for those individuals. Some of the things they help with outreach and education. They help people scheduling doctor's appointments, getting insurance, finding transportation, and accessing food assistance programs. They do chronic disease management. They help them with their diabetes, their asthma, their heart disease. They help them get monitoring on those. They do a lot of work in maternal and child health. They work with pregnant women, new mothers. They help them give with prenatal care, nursing, early childhood checkups, and a lot of other things. Texas has a very robust program that they are using in there with mental health supports. As we all know, the health system is difficult to navigate, but when you try to navigate the mental health system, it becomes even more complex for so many of our Mississippians. One of the other things too is that they ensure cultural competency, because it's usually somebody within somebody's own community that's helping do this. Looking at the outcomes that they presented at these national meetings, and that the health department has mentioned, well, Dr. Edney is a huge proponent of this, is they improve health outcome. They help reduce those health disparities. They improve chronic disease management. They help in communities when they see needs and unmet needs being met. They help people navigate that. They're extremely cost effective. Because it's a way to reach those underserved populations and get them oftentimes into preventative healthcare, which really helps us. Many of these community health workers have a high school diploma and maybe some additional training or college. But one of the things that this bill will seek to do is it will provide that the Division of Medicaid seeks approval from the Centers for Medicaid and Medicare Services for a state plan amendment to provide reimbursement for these certain services provided by community health workers. The department will become the certifying body of the community health worker. They will promulgate rules that are necessary to carry out the provisions of this act. They'll establish the core competencies that are needed to be a certified community health worker. They'll create the application, the renewal process, the renewal fees, and work on any denial, suspension, and revocation for those. They will do a competency-based training program and train providers and organizations so that we can increase the number of community health workers. Right now, the Department of Health has 25 community health workers that are internal to the State Department of Health that serve the non-public health districts. They have 18 that are positioned in community-based organization. They have 6 that are scheduled to be hired right now to promote maternal and child health within underserved communities. And they have 9 additional right now that are to be hired to work in the STD and HIV management program. That is a vast explanation of the bill, but I'm happy to answer questions.
So thank you for your work on this, Senator Boyd, and for the excellent explanation. Are there questions from the committee? Seeing none, Senator Barrett for a motion. Have a motion. All in favor, say aye. Any opposed? Okay, that bill will be reported. I'm going to jump ahead to just real quick to 2218. I know Senator Harkins is here and has something I think he needs to attend to at the end of this. So we're going to call that bill up. I'm going to recognize him to present his bill.
Thank you, Mr. Chairman. I appreciate it. Ladies and gentlemen, what's before you is the establishment of a Mississippi-Ireland Trade Commission. We heard earlier in the session from the president of the Irish, our friend Mark Daly was here. on a little promotion tour and came by and spoke. But I think what basically the bill does is it sets up a trade commission that establishes relations between Mississippi and Ireland. A lot of, countries are going directly to the states because there's not a whole lot of activity. There's a lot of logjam in Washington, D.C. And so they're going directly to the states to try to create trade commissions that work on several different levels, whether it's trade and universities, a lot of collaboration opportunities there. And I think Ireland is our 12th largest trading partner, and it is the only English-speaking EU country left. So a lot of trade is going through Ireland into the EU. And anyway, this would establish a trade commission that would be 10 members. The governor would appoint 3, the lieutenant governor would appoint 2, the speaker would appoint 2. President of Mississippi Economic Council would have an appointment on there. The executive director of the Mississippi Development Authority or his designee shall serve as an ex officio member. Commissioner of Institutions of Higher Learning or his designee shall serve as an ex officio non-voting member. And all the appointments have to have the appointments on the Economic Council, the speaker, the governor, and lieutenant governor shall have either current or past involvement in organizations that promote Irish affairs or interest in the well-being of trade relations between Mississippi and Ireland. There are 4-year appointments after the initial appointment. Some of them are staggered. All members will serve without compensation and at the will and pleasure of the appointing authority. The commission shall elect a chairman and other such officers as it considers necessary from its members. So that's kind of an explanation of the bill. It's pretty short and sweet. So I'd be happy to answer any questions if there are any.
Questions for our Chair of Finance? Seeing none, is there a motion?
Title sufficient, be passed.
All in favor, say aye. Any opposed? Okay, that bill will be reported. Next, we also have Senator Delano, who was hiding behind Senator Thompson a moment ago when I was looking for him. We're going to call up Senate Bill 2649 and recognize him to explain the bill.
Thank you, Mr. Chairman. I appreciate you allowing me to present this bill to your committee. This is a referred bill that came from Environmental Protection. This is something that the Department of Environmental Quality has asked for an additional authority, and it's only one part of a program that where we're trying to reduce the time frame for permits through DEQ. And what we're asking permission for and authority for in this bill is to allow the department to contract with either a private corporation, or they may have an opportunity to do it with someone in-house, to review, evaluate, and process permit applications or certificate applications. And this is a program where the applicant would be willing to pay an additional fee for the actual cost for the evaluation, the review, or the processing of the permit. That would be in addition to their normal application process. The reason why we want to do this is to make sure that there is some, I don't want to say surety, but some reliance that they would be able to get that permit done in a quicker or a more predictable manner. And this is not, again, supposed to be anything that replaces a normal application process. But this is something that's very similar to what we do with MDA on a lot of their major projects. So it just gives us a tool in the toolbox. And that's an explanation of the bill, Mr. Chairman.
And I did have an opportunity to speak with the executive director today, along with the lieutenant governor. We wanted to make sure there were not any reservations or any problems. And as I understand it, there's not a fee now, so this accelerated kind of method would require a fee. And just like you said, in a unique situation would accelerate the development of the project. So questions for Senator Delano? Senator Blunt.
Senator Delano, it just seems to me that when I was in school, if I wanted to get my grade back faster and I could pick and pay the teacher who was going to give me my grade, that I would have a clear incentive to pick since I'm paying that teacher's salary, I'd get a good grade. And it seems to me that if this is a public function, a regulatory function, and it ought to be paid for with public dollars. And if they don't have the money to move these things quickly, and if they say that, I have no reason to doubt that, then that's on us. And the idea that a person who is regulated by the department can choose and pay for the entity that's going to judge their permit application, that's a clear conflict of interest. And it ought to be done by the department with public funds to carry out a public function. Do you think that's right, or do you think I'm wrong about that?
Well, I just want to clarify one thing. I just want to make sure that it's known that the applicant would not be able to pick who that person would be. It would be up to the agency to pick a qualified consultant, or like I said, they could do it in-house. I do agree with you completely, and I've actually had multiple conversations with my chairman of appropriations about making sure that they have the funds that are available to add a pin as necessary, or to do whatever's necessary to reduce the time frame. Where this is useful is if it's a very large project that is very it takes a lot of dedicated eyes or dedicated review of a project, where the applicant is willing to say, okay, Director of DEQ, you have told me that the direct cost associated with the review and the evaluation of this proposal is going to be X, and let's just say it's for $4,000. Then that's the cost that would go to the taxpayer, or the applicant. The applicant would not know who the consultant would be or who the person within the agency would be. So it's still along the same lines, but I agree with you 100% that this should be a function. This is just a tool in the toolbox that can be used to help provide some stability, or at least some alleviate some of the concerns that applicants have had, where they don't know how long it's going to take to get something reviewed. This will give them the opportunity to have some assurances on how long that review process will take.
Would it be better to just let the department set whatever fees they think are necessary to grant a permit in a timely manner?
Well, just as you stated, sir, and which I do agree with, I think that is a state function. And I don't know exactly what each application costs for you today, but I know that I've personally had to make some applications, and they were nominal fees because this is a review, and it is just it should be something that's part of the agency costs, and something that they do for taxpayers. What we're trying to do here is to try to, I don't want to use the word expedite, but I want to provide some realistic expectations of how long that's going to take. And if you can or if the director has the ability to go out and hire a consultant, or to have a consultant that will give them a specified time frame for that review, then it will make it easier and more predictable for the project to be able to move forward. Because many of these economic development projects are on shorter timelines, and we've got to do something to reduce the times that are currently at 120 to 180 days. And this is one way that we're able to do that.
Thank you.
Senator Blunt, to your point on that too, one thing too that I also received is just the sheer number of backlogs right now at MDEQ because of their inability to get and recruit the engineers and permit writers that they need. So this may be one of those situations where, like we're dealing with in other things, that over time it might correct itself, and the need for this may go away should the agency be able to fill those deficits. I see Senator Hobson kind of pouncing on that point there, but at this stage of the game, they feel like they are slowing projects down because of their inability to act in the speed and the ability that they would like to, and with some of the advancements in the state, that's their request is to be given special consideration on this. Senator Hobson.
Thank you, Mr. Chairman. What you just said and Senator Delano's earlier statements, I think, are spot on with the situation with DEQ right now. But this is, as he said, a tool that would help expedite the process because there is a backlog. And look, this is not uncommon amongst all of our agencies. And there are some specific issues to DEQ of which we have spoken, but we have a lot of agencies that are just having a hard time filling vacancies. And there's some other reasons with DEQ too, but I would say maybe a solution or help here is just put a 4-year repealer in this so this doesn't go indefinitely. If there's no problem with that, then that way, if we can get caught up, I agree that they need to get some backlog because it's holding back economic development in our state.
Right.
And this is a tool, as you said, but if that's helpful, because I respect the concerns that Senator Blunt has raised, and I'll hear from Senator Delano if he has thoughts on that. Otherwise, I would make that motion.
And I would agree too, Jim, much like we did with our telework provisions coming out of COVID, that, kind of time limiting it to some degree to have us look at it again would be, if that would help with some of the concerns, I would certainly, be in favor of such an amendment. And I assume you were offering that amendment. Do you want to speak for or against the amendment?
Mr. Chairman, if you don't mind, since this bill is double referred and this is the last meeting of the day, can I do this on the floor?
Yeah, so excellent point. Late in the day, I should have picked up on that. So Senator Hobson, if you wouldn't mind withdrawing your amendment for now, we will add that on the floor and take that action there. So with that, any other questions on this bill? Title sufficient to pass. All in favor say aye. Any opposed? Okay, that bill will be reported. Okay, next we have Senator England, a double referred bill, Senate Bill 2576. We just took up this afternoon in elections. I'll recognize him to explain this brief bill.
Thank you, Chairman David Parker. I appreciate you letting me explain
Senator
this bill.
David.
Well, that's
Almost.
Yeah.
Brett, we feel it, man.
Well, I guess time to
Yeah,
go.
just to move really quickly. So this was amended in the, we've got a committee substitute. We had a very good amendment from Senator David Blunt earlier. This deals with photo IDs and what constitutes a current and valid photo ID. The Secretary of State asked for this bill. You'll see that what was added, just to let you know, is the language there says under the Administrative Procedures Act, and then including but not limited to providing what constitutes current and valid voter identification in regards to identifying voters. This is there's been some legal discussion on whether the Secretary of State has authority to deal with this. With regards to what constitutes a valid and current photo ID. As you know, voters are allowed to use a ID that is within 10 years old. And that is essentially the reason for this bill. I really wouldn't be happy to answer any questions, but I'm sure the gentleman from the Secretary of State's office would be happy if the chairman should recognize them on this bill, but that's an explanation.
So in your committee, Senator Blunt added an amendment to it, and I did not have the opportunity to speak to the Secretary of State's office about that when the amendment was added, and so I did not vote for the amendment in committee because I did not know, their opinion on that. But I've had an opportunity to communicate with them via text since then, and they consider that to be a good amendment, that strengthens the intent of the bill. So I just want to share that with the members who may be on both committees. But any questions for Senator England? Senator Turner Ford. Yes.
Thank you, Mr. Chairman. So section 2315-563 of the code, as I read it, specifies the valid types of ID that shall be accepted. So what will we be authorizing the Secretary of State to do regarding the promulgation of rules?
So if I could answer, and then you can add in, the situation as I understand it is that the Secretary of State's office has been, through a rule of their own, accepting an ID that is no longer valid. For example, a driver's license that might be older than the 4 or 8 year period, and accepting that and allowing people to vote with that. So that's through a rule that they've made on their own. And I believe they want this bill to reflect the fact that their intent and their desire is to make it easier for people to present ID and to not restrict them to having to have, for example, a valid driver's license, or one that's been updated. I may be speaking out of turn, Senator England, but I know I've been to the airport before and been very surprised when somebody told me that my driver's license had expired. And it's not a good feeling if you're trying to get on a plane. It's probably a worse feeling if you're trying to show up to vote. So I think that's the intent, is just make clear that the Secretary of State is doing everything they can to ensure through their rules and regulations that ability is continued.
So the question that occurs to me is if we want people to be able to just use any driver's license that's been issued, regardless of if it is expired or not, why not just say a Mississippi driver's license and just change the statute?
So, well, that's not the bill we have before us. The bill before us is to allow the Secretary of State to promulgate the rules and regulations that they need, I think, to ensure what you're describing. And it's been mentioned to us, at least it was in committee, that there is someone who has threatened a lawsuit over that. And the concern is that lawsuit might bring into jeopardy, some of our voting provisions. So
can we give the Secretary of State's office rulemaking authority that would not coincide with statute?
I think we're just giving their office the ability to accept and have rules on the type of ID they have. Senator Blunt, you may have a better understanding of that, or Senator England. Both of you may have a more firm understanding on that. If you wouldn't mind, if your intent with the microphone is to answer a question, I'll recognize you for that, if you would. Senator Blunt.
Thank you, Mr. Chairman. After the meeting, I talked to Senator England, and my concern is the same as yours. You can't pass a regulation that is contrary to statute. So we're talking about it. We want to keep the current, at least I'm speaking for myself, and I think for the Secretary of State's office, what they said this morning, we want to keep the current practice in place, that a driver's license, whether or not it is expired or not, if it verifies your identity, that's all they're attempting to do. So as the bill is before the committee, I share your concerns about that, but we're going to keep talking about it. And I think, I wouldn't want this to die here. It would have to go back, and we're going to keep talking about it. And I think we can address your concerns are the same as mine, and we're working on it.
And I'm not trying to defeat the bill. I guess my question is, what is it that we can anticipate seeing as these regulations are implemented? And then my second question is, in the event the Secretary of State does promulgate rules and regulations, when would we as a legislative body have an opportunity to review them?
I'll defer to the Chair of Elections.
Yeah, thank you, Mr. Chairman. And thank you very much for your questions, Senator Turner Ford, and for your comments, Senator Blunt. I will confirm that we are going to continue to talk about this. There's obviously, having worked at my polling place and having gone through the training to do that, we are told when we're looking for photo IDs, we're not worried about a driver's license being current and able to get a person to and from, driving with a license that does not work for, say, the Department of Public Safety. We're just looking for photo identification. And what we have been taught is that ID is current and valid for the purposes of having a photo identification in order to vote. Is a photo identification has been issued within the previous 10 years. And I understand that to be the intent of the Secretary of State here. That is what they want to do. And of course, we're looking at an election year ahead of us. So this was a measure that was brought forward to allow them to respond to this one particular county that brought this issue to them with regard to the language current and valid. I appreciate you bringing up the question, and of course, any amendments in here would be a defeating amendment at this point, but we will look at this on the floor, and if there is a better way that we can do this and get it rolling, I'm certainly willing to hear about it and discuss it before we get to the floor. And I believe that the gentleman from the Secretary of State's office would probably agree with me on that we just want to make sure that someone showing up with an ID that may be expired by 1 year is not going to have an elections commissioner that has instructed them not to accept that as a photo ID. That's an explanation. I know it might not be the answer we're looking for, but we certainly don't want unintended consequences to come about by not passing this bill now, but we will continue to talk about it.
I'll just share too that, one thing I'm already enjoying about this committee is that it seems that we try to come up with all of the questions or potential answers to the questions before the bill makes it to the floor. And so I'm look forward to the chairman's work on this to try to move that issue forward. So if there are no more questions, the motion on this one would be, because we do have a committee sub, so for motion.
Sure. Motion's title sufficient, do pass committee sub.
All in favor, say aye. Any opposed? Okay, so that bill will be reported. Okay, the last bill today is Senate Bill 2917. And just a little background on this. This had a companion bill on the House side by Representative Ronnie Crudup. And it's been made, I've been made aware that this did not advance out of the House today. I may be incorrect on that, but we certainly want to keep this alive. It does just a couple of simple things. So on lines 41 through 44, it just adds a provision that it adds removal of blight to the authority of the Capital Complex Improvement District Board in case they receive grants or other money to do this. That does not, it allows them to do this. And then in section 2, lines 50 through 51, it just provides that the board may implement and oversee projects paid for with funds from the CCID board or other funds appropriated by the legislature. So that's a brief explanation of the bill. Are there any questions?
Make a motion.
Senator Blunt for a question. Sure.
I don't have a problem with this bill. The Capital Complex Improvement District is a street paving and infrastructure effort that I think is working very well. If you look at State Street right now, in front of the old Capitol building, that project is being paid for CCID dollars. It's state investment in infrastructure. I consider this to be infrastructure. I have no problem with it. My only request would be, we have Senator Harkins and Senator Hobson here. We don't need to, they're only getting about $10 million a year. And that money, they could spend a lot more money than that. So I'm somewhat nervous about taking on additional responsibility that would draw funds away from the necessary street paving work that is happening. So let's look for more opportunities to put more money into this program to do what they're doing, because I think they're doing good work. Thank you.
And I think you and I share the desire to try to give Jackson the assistance they need in a lot of different ways. So I appreciate the comment. So any further questions on the bill? If not, is there a motion? A motion title sufficient do pass. All in favor, say aye. Any opposed? Is there a motion to rise and report? Shelby?